a couple pints of vodka.
All right. Were you stopped by the police or was there an accident?
I was approached by police at my apartment door.
Okay. You drove to your apartment?
Yes, sir.
All right. And then the police arrived?
Knocked on my apartment door. Yes, sir.
Okay. So you drove there, went in, police arrived.
Yes, sir.
All right. And were you ultimately arrested?
Yes, sir.
All right. Are you challenging the right of the police, number one, to detain you and stop you, or the arrest in this case?
No, sir.
All right. And after being arrested, were you taken to the hospital?
Yes, sir.
All right. Let me ask you this question. And there was a blood test?
Yes, sir.
All right. Between the approximate time between the time that you drove, parked the vehicle, went into your place, how much time elapsed between the time that you drove and the time that the police arrived?
Before this courtroom session is over, we're going to see multiple defendants, multiple plea deals, and one jaw-dropping drunk driving admission that even the judge pauses to double-check. This is a docket that starts routine, but quickly turns revealing. We've got waived hearings, felony negotiations without jail time, a defendant who never even makes it to court and gets hit with a warrant, and then, the main event, a repeat drunk driving case where the defendant casually admits to drinking a couple pints of vodka before getting behind the wheel. And here's where it gets serious. When Judge Simpson starts walking through the rights, the timeline, and the blood test evidence, what initially sounds like a standard plea suddenly escalates into something far more alarming. A .262 BAC, more than 3 times the legal limit in most states. So the question becomes, is this just another plea bargain, or a clear sign of a dangerous pattern the court is trying to stop? As we go through this hearing, watch closely how plea agreements are structured, how prior convictions matter, and how quickly the court pivots from administrative routine to serious accountability. Because by the end of this session, one thing becomes very clear: the justice system isn't just processing cases, it's confronting behavior that could have turned deadly.
That's called the case. People versus Jadon Briscoe.
Ready.
Andrew Childers appearing on behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Briscoe. Mr. Briscoe, go ahead on mute and state your name.
Defendant Briscoe.
And he's waving.
We are waiving exam, Your Honor. There is a bit of a attachment to it that Mr. Childers, I think, is going to put on the record.
Your Honor, the understanding is that Mr. Briscoe will waive up. We will ultimately resolve this matter in circuit court with some sort of felony resolution that would not include incarceration. I believe the understanding is that it would also include HIDA. Is that fair, Mr. Simon? Is that what we discussed?
That is what we discussed. Thank you.
Okay.
All right. And Mr. Briscoe, you're waiving your right to a preliminary examination?
Yes, Your Honor.
Do you understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts.
What you're seeing here is classic lower court procedure moving at high speed. Judge Simpson is processing multiple defendants in sequence, and each case represents a different stage of the criminal process. Some defendants are waiving preliminary exams, which essentially means they're giving up the chance to challenge probable cause and moving straight toward resolution in a higher court. Others are requesting hearings, buying time to review evidence or negotiate. But notice how smoothly this operates. Plea waivers, bond conditions, scheduling, all handled in seconds. That efficiency isn't accidental. Courts like this run on negotiated outcomes, not trials. And when you hear phrases like bound over, stand mute, or not guilty entered by the court, those are procedural safeguards ensuring defendants' rights are preserved even when they don't actively speak. So while it may sound routine, this conveyor belt rhythm is actually the backbone of criminal case management, and it sets the stage for the far more consequential plea we're about to witness next.
Mr. Simon.
Waive formal reading, stand mute to the charges, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea as to all charges. Pretrial will be set for
March 9th at 1:30 for judgment.
March 9th, 2026, 1:30. Judge Hamud. Bond will continue. Thank you.
Thank
Court
you.
does call the case. People versus Edward, is it Dagnus?
Your Honor, there's two things. One, we'd like to modify bond. There was a consent bond condition order.
All right, that was stipulated to. Okay, I will sign that order.
And regarding the PCC, I'd like to set this matter for a preliminary examination.
Discovery is complete.
Yes, Your Honor.
Preliminary examine and people would have their witnesses available January 27th.
Yes, sir.
Preliminary examination in person will be set January 27th, 2026, 9 a.m. before Judge Barr. Bond will continue with the modification as to the no-go to and no contact provisions by stipulation.
Thank you very much, Your Honor.
Thank you.
Good afternoon, Your Honor. Edward Drugas on behalf of Javon Webster.
Your name?
Javon Webster, sir. Your Honor, I'm asking for a preliminary examination,
Discovery is complete.
to my knowledge.
People have their witnesses available the 27th. Preliminary examination in person will be set January 27th, 2026, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court recalls the case. Ms. Parody, any? No. You want me to call it now? Or want me to wait? I mean, I got one more block left if you want me to, but it's gonna matter.
I guess if I get an update, I can, if we call it now, if I get an update, I'll contact you.
All right. Court does call the case of People versus Laura Walder. Recall.
Assistant Public Defender Lauren Perny on behalf of Ms. Waldron. You know, I have attempted to contact Ms. Waldron after our bench conference. I don't really have an update for the court. I'm hoping that I can get her back in touch with us. I'll file if the court's gonna enter a warrant, I can file a recall as soon as she's available to do so.
Bench warrant will issue for defendant's failure to appear. There is a bond violation or at least alleged violation also. So bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Darby Jensen standing in for attorney of record Robin Kennedy on behalf of Mr. Smith. Mr. Smith, can you please state your name for the record?
Yes, Nicholas Smith.
1 year, $1,000 fine, I think. All right. I have a plea form in front of me. That's what we're doing.
Yes, correct, Your Honor.
All right. Plea form indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year offense. On the successful plea to that charge, count one, OWI third, would be dismissed. There is also the understanding that the defendant agrees to participate in sobriety court with 54A District Court as a condition of the plea agreement. That's the court's full understanding.
That is my understanding as well, Your Honor.
That's correct, Your Honor.
May I have him sworn, please?
You solemnly swear or affirm the testimony you're about to give the truth, nothing but the truth, so be that.
Yes.
Lower and state. Spell your name.
Nicholas Smith, NICHOLAS, Smith, SMIT.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes,
That is a misdemeanor punishable by up to 1 year incarceration. up to $1,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes.
and because you believe that you are indeed guilty?
Yes, sir.
On date of April 19th, 2025, at the location of Textile Road near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
A couple pints of vodka.
All right. Were you stopped by the police or was there an accident?
I was approached by police at my apartment door.
Okay, you drove to your apartment?
Yes, sir.
All right, and then the police arrived?
Knocked on my apartment door. Yes, sir.
Okay, so you drove there, went in, police arrived.
Yes, sir.
All right. And were you ultimately arrested?
Yes, sir.
All right. Are you challenging the right of the police, number one, to detain you and stop you, or the arrest in this case?
No, sir.
All right. And after being arrested, were you taken to the hospital?
Yes, sir.
All right. Let me ask you this question. And there was a blood test?
Yes, sir.
All right. Between the approximate time between the time that you drove, parked the vehicle, went into your place, how much time elapsed between the time that you drove and the time that the police arrived?
Less than 2 minutes.
Okay, gotcha. All right. And so you were at the hospital, there was a blood draw. What were the results of that blood draw, sir?
Off the top of my head, I think it was like 0.2 something.
Does anybody have the actual?
I do not have access to his discovery at the moment, Your Honor, but I could get it if need be.
One moment,
Joe.
Your Honor. Just take me a second.
I'm sorry?
1 second, Your Honor. I'm pulling it up.
Oh, okay. I didn't do the arraignments. I don't think it's written.
It was a .262, Your Honor.
262.
This is the moment the entire hearing pivots from procedural to deeply concerning. When Judge Simpson asks for the blood alcohol result, the defendant initially downplays it, like 0.2 something. That alone suggests heavy intoxication. But then the actual number comes in, 0.262. To put that into perspective, most jurisdictions set legal impairment at 0.08. At 0.262, cognitive function, reaction time, and motor control are severely compromised. Many people at this level struggle to stand, let alone drive. And remember, this is a second offense, meaning the court is legally required to consider prior drunk driving history when evaluating risk and sentencing. What's equally striking is the timeline. He drank multiple pints of vodka, drove home, and police arrived within minutes. That proximity eliminates many common defenses like post-driving drinking or delayed testing error. From a legal standpoint, this is one of the strongest factual bases a plea can have. So here's the question for you. When someone reaches this level of intoxication and still drives, is punishment enough, or is treatment the only real solution?
Sir, do you have any reason to dispute those blood test results?
No, sir.
And sir, had you previously been convicted of operating with a high BAC on or about October 25th, 2016 in the 55th District Court and or operating while impaired on or about April 3rd, 2017 in the 55th District Court?
The first one, yes.
You don't recall the other one?
It was earlier than that date, but they were like back to back, so.
They were like back to back. Well, were the offenses back to back or were the time of the convictions back to back?
Offenses, yeah, sorry.
Yeah, okay. So
Yep.
that's a conviction date. So you're
Yeah.
not disputing those conviction
No,
dates
no,
that I
sir.
said? All right. Sir, if I accept your plea, I do have to advise you that if between the time of your plea and the time of your sentencing, in this case, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, nor would the court be bound by the sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your
And
Honor.
on behalf of the people.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, sir.
People are satisfied.
All right. Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1. Has he already done the assessment for the court, the 54A?
Yeah, I sent in a treatment that I had done earlier in the year. And
Pardon?
yes, sir. Yes, they have an assessment on file for me.
Now we're seeing how the justice system balances accountability with rehabilitation. Judge Simpson accepts the guilty plea, dismisses the higher charge, and orders a pre-sentence investigation, which is crucial in repeat OWI cases. That report will assess substance use history, treatment needs, and risk to the public. Notice something important. The plea agreement includes participation in sobriety or treatment-based court. That's not leniency, it's targeted intervention. Courts know repeat drunk driving is strongly correlated with alcohol dependency, so structured monitoring and treatment often reduce reoffending more than short jail terms alone. But the prior convictions matter enormously here. When a defendant has back-to-back alcohol-related driving offenses in their history, the court views new conduct not as an isolated mistake, but as a pattern. And legally, patterns justify escalating supervision, stricter conditions, and sometimes incarceration if compliance fails. So what Judge Simpson is doing right now is setting the framework: accept responsibility, enter treatment, or face significantly harsher consequences at sentencing.
Okay, so you did an assessment. Okay, make sure to at least provide the assessment to my probation department here. Okay, for time for sentencing. With reference to that, is that court, did they give you a date or any other information as to when they want him in there?
No,
Otherwise, I'll just set it on my normal sentence.
they have not
They have
indicated
not.
anything that I'm aware of.
All right. Sentencing in this matter will be,
Carolyn Foster Tucker on behalf of Malik Gaines.
your name?
Lee Gaines.
And Your Honor, we're requesting an adjournment for more time to review discovery and work towards a
Did
resolution.
you just get it or what's the deal? You just
Mr.
got this case, basically.
Mr. Bernstein got it recently, yes.
Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the people versus James Williams.
Alex Jablowski for the people.
Good afternoon, Your Honor. Christina Constantino appearing with and on behalf of James Williams.
Wow, really?
Live and in the flesh.
Wow. I didn't even see her sitting over there.
Yeah, got my snow boots on today. so-
Oh, that's why.
Yeah.
Okay.
Yeah.
All right.
Mr. Williams, can you state your name for the court?
James Williams.
Thank you. The court has before it a plea form that indicates that the defendant would be pleading guilty to 3 misdemeanor charges. Count 4, I believe that's an added count 4, and count 5, both of attempted resisting and obstructing a police officer. A misdemeanor, those are 1-year offenses. And then a count 6, malicious destruction of property, 200 to 1,000, also a 1-year offense. On his successful guilty pleas to those charges, counts 1 through 3 would be dismissed. There is an agreement between the prosecutor and defendant to deferred sentencing under 771.1. That is the court's full understanding.
That's our full understanding as well, Judge.
Yes.
All right. May I have him sworn?
You solemnly swear or affirm the testimony you give the truth, the whole truth, and nothing but the truth, so be it. Lower your hand, state and spell your name.
James Williams, JamesWilliams.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
First 2 counts 4 and 5 are attempted resisting and obstructing. Actually, I think this one is a police officer. Yes. Attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes, Your Honor.
And also count 6, which is malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is injured or otherwise destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
All right. To the charge of attempted resisting, obstructing a police officer is contained in count 4. How do you plead?
Guilty.
To that same charge as contained in count 5, how do you plead?
Guilty.
To the charge of malicious destruction of property, 200 to 1,000, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes, Your Honor, I did.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your
and because you believe that you are indeed guilty of this offense?
Honor. Yes, Your Honor.
June 10th, 2025, at the location of 2700 International Drive in Ypsilanti Township, Washita County, State of Michigan. Did you come into contact with 2 deputies from the Washita County Sheriff's Department?
Yes, Your Honor.
What happened?
Your Honor, may I voir dire my client?
Yeah, I'd rather you guys ask the question. I don't know.
All right. Thank you, Judge. Mr. Williams, on that date when you encountered at least two different officers, correct?
Yes.
And when you encountered those officers, they attempted to detain or arrest you that day, correct?
Yes, ma'am.
And at that time, you attempted to resist or obstruct them in the sense that you tried to avoid being arrested, correct?
Yes, ma'am.
And what I mean by that is you physically moved your body away from the officers to try and avoid them being able to arrest you.
Yes, ma'am.
Okay. And you would agree that you attempted to resist and obstruct both of those officers that day?
Yes, ma'am.
Okay. That day you were actually arrested and placed into a police car, correct?
Yes, ma'am.
And there was a dash camera that was mounted to the car, correct?
Yes, ma'am.
And do you agree that you caused damage to that dash camera that was mounted to the police car?
Yes.
And would you agree that damage that was caused or the item that was damaged was valued at between $200 to $1,000?
Yes, ma'am.
And you didn't have permission to do any of that day, correct?
No, ma'am.
With that, Your Honor, we'd be satisfied.
All right. Sir, if I accept your plea, if you have to advise you that if you commit misconduct as defined in the Michigan court rules between the time of acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. Do you understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
All right. And have I complied with the court rule?
Yes.
You have, Your Honor.
All right. The court will accept the defendant's pleas of guilty to counts 4, 5, and 6. Counts 1, 2, and 3 are hereby dismissed. The pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 19th at 10 a.m. before Judge Washington.
February 19, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you very much, Your Honor.
Thank you. Thank
Have
you.
a good rest of your day. Good to see you.
This courtroom session shows exactly how the criminal justice system handles repeat offenses and negotiated resolutions in real time. We watched multiple defendants move through procedural stages, waiving hearings, requesting examinations, and negotiating pleas. But the most serious moment came in the OWI second offense case. Nicholas Smith admitted to drinking large quantities of vodka, driving, and registering a .262 blood alcohol level, with prior drunk driving convictions already on record. Judge Simpson accepted the plea to the reduced charge, dismissed the more severe count, and ordered a pre-sentence investigation that will determine treatment needs and sentencing conditions. The key takeaway here is that repeat impaired driving isn't treated as a one-time lapse. It's viewed as an ongoing public safety risk requiring structured intervention. The court's goal now is clear: reduce the likelihood of future harm while holding the defendant accountable. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.